Thank you. Council, good morning once again.
Good morning, my learning friend. My learning brother.
Yesterday we had a show here, and it was an interesting. But I've been following the response of our viewers on YouTube. Some they misinterpreted it that we are attacking Uganda, that we have started the war against Uganda. Yet we are looking at the historical constitutional development of Uganda. These are things which happened before. So we as a students of law, we are studying them. So we decided to bring them to your attention for you to know what transpired before. Now, yes, other people, they are saying that we do it in Uganda, but yet this course is in English for sure. But we shall be mixing. But all in all, we appreciate for your response, and I will be updating you on different courses. We are still looking at the constitutional law. It's about our history. It's about what transpired before. Tomorrow we shall be coming with it. Criminal law, where we shall look at different cases. Some cases you know them, others you don't know them. Some cases they are currently like the Christopher Kello case. It is now a reference.
It has become a precedent.
It is now a case law. It is now a precedent. It can be referred to while determining other criminal cases down there. So tomorrow we shall be handling criminal law. Council today, let's look at the order in council. Order in council. For our viewers, order in council, it was the first amendment of the 1900 Uganda Agreement. It made some classifications, some amendments from the first legal document, that is the 1900 Uganda Agreement. It became a binding document, so it kept on growing. Amendment a document is a growing document. Okay, it keeps on changing, it keeps on developing. So we are going to look at order in council. These are questions which are always the examiners said in this paper, Constitutional Law 1. Okay, of which I would like to be a good constitutional lawyer.
And you can make it.
Years. Yeah?
You can make it, and you defend our legal framework.
And I defend the legal framework of Uganda. You are seeing how laws are being made, like that one of yesterday.
The sovereignty bill.
The sovereignty bill. It lacked some. It violated some constitutional provisions, and I'm very sure it's going to be challenged in the constitutional court. Yes, much as they changed some clauses, but it will be challenged in the constitutional court.
Of course, as a citizen, you have that right. When you look at Article 137, Clause 3, Paragraph A and B,
yes,
if another person or parliament passes a law, but you, a citizen, feel like that law is infringing your rights,
yes,
then you can go to constitutional court and seek redress for the interpretation of that law. That's Article 137, Clause 3, Paragraph A.
137, Clause 3.
Paragraph A and B in the Constitution.
30 what? 37?
137, Clause 3, Paragraph A and B. Questions as to the interpretation of the Constitution, they are handled by the Constitutional Court.
It reads as follows. That's for question as to the interpretation of the Constitution. Paragraph 3. You said paragraph 3?
That's clause 3.
Clause 3. Yes. A person who alleges that A.
That's a paragraph now.
Yes. Any act of parliament or any other law or anything in or done under the authority of any law. B. Any act or omission by any person or authority is inconsistent with or in contravention of the provision of this Constitution may petition the Constitutional Court for a declaration that to that effect and for redress where appropriate. So to those who are
not satisfied with
yesterday's proceedings,
the only remedy they have, they can now go to the Constitutional Court and then they are hoped out. Yeah. So now
the problem we are having with our judicial system now, that we have many constitutional, regime judges now. That is the problem.
But they take the oath.
They take the oath, but
they
the
take
practice,
the oath.
Politics supersedes law.
That's a matter of argument on the other day. But apparently for us, we do believe that if any person is not certified, don't do mob justice, don't do anything.
But I'm sure that law is going to be what? That act is going to be challenged in the Constitutional Court. But let's go back to our main subject matter.
Now, when you come back to that track, Council, you are talking about the 1902 Order Council. Yes. Whatever we are going to look at right now, have it in mind that we are discussing but connecting it with the current Supreme Law of the land. That's the 1993 Ugandan Constitution.
This one?
Yes, that's why we call it constitutional law. To what degree did it contribute to the development of our constitution? Now, when you look at this 1902, it's like it was the first, like they said, amendment, meaning things that were still lacking in the 1900 Uganda argument. They did a polishing, and then they formulated the 1902 order in the council. Now, when you look at it, it was like the first constitutional document, the first constitutional legal framework of the land. There's no any country that can be governed without the rule of law. One of the core values or elements to portray that there is the rule of law, there must be the supreme document that governs the entire
country,
society. Now, when you look at this 1902, it was the first fundamental legal framework that covered the entire protectorate of Uganda. Remember, this 1900 Uganda argument, for it was within Uganda. Though we are seeing that some of the articles were also emerging with the rest of the protectorate, but for it was majorly within Uganda. It was favored more of the Uganda. But now, we wanted to get a document that was going to govern all of us. The people from the Ankole, from people from Acholi, people from Uganda, the entire protectorate. So, our colonial masters came out with the 1900 order in the council. Now, when you look at it, it's slightly, there's a slight difference between it and the 1900 Uganda argument. In that we are going to see that in the Uganda argument, we read it more with the articles. But here we are going to look at it more with the sections. So you're going to find that some of the sections, they are similar. They are the same as the articles of the Uganda argument. But now we are going to see where the uniqueness comes from. What you have to know in your mind is that this one was the first legal framework of the entire protectorate. But for Uganda, it was major for that specified part of the Uganda region. Now, when you look at section 1 of the order in the council, it talked about the territory boundaries of the protectorate.
Defines the boundaries of Uganda.
The entire Uganda.
And
where does Uganda?
Division is of the protectorate.
Yes, where does the Uganda pass? That boundary, what you call the map of the Uganda, it came from the section 1. It gave the demarcation of the entire protectorate of Uganda. The entire map. Not Uganda alone. Now we are on the entire Uganda. Remember, for Uganda argument, under Article 1, for it gave the boundary of Uganda as a kingdom. But now for section 1, this section 1, it gives the entire demarcation of the protectorate. So now we know that Uganda comes from here, it gives the horn to northern Uganda, comes to western Uganda, borders Rwanda, like this. So it was section 1 of the order in the council that gave us that. Now, we shall also come and look at it. Section 4.
So it relates with which article?
Now, when you come to our constitution,
yes,
we shall come and relate it with Article 177 and 178. Yes, and 178. So you're going to see that whatever we are discussing, we must be rating it with the current supreme law of the land, which is of the Constitution of 1995. Now, we are also going to see that for it, they drafted it in a funny way that they were combining some sections together. Yes. Now, from section 1, we shall skip 2 and 3. We shall come now to section 4 and 5. Now, when you look at section 5.
So before you go to section 5, Article 177 and 178, under the 1995 Constitution, those are the articles that talks about
the demarcation, yes, of the district and of the regional governments.
Yes.
Meaning now we know that Kampala passes here.
Yes.
We know that Mwero passes here.
Wakiso.
That's at 177. Then 178, I think it gives the regional government. This is the region of North Ankole Central.
So the framers of 1995 Constitution borrowed knowledge and literature from the 1902 and from 1900 Uganda government.
Yes.
Okay. That's okay.
Now, we are going to go and we look at section, is it section 4 to 5?
Yes.
For it, it gave the office of the commissioner to be assisted by his deputy.
Yes.
Now, we shall come back and relate it with our constitution. Meaning the commissioner was the head of the protectorate, right?
Yes.
Now, we shall come back. When you look at the constitution, is it Article 98? It talks about the president of Uganda. And it says, there shall be the president of Uganda. Let me see. 98. Yes, the president of Uganda. Under Article 98, Clause 1. Clause 1 says, there shall be the president of Uganda, who shall be the head of state, head of government, commander-in-chief of the Uganda People's Defense Forces, and the fountain of honor. But remember, on section 4, they are telling us there shall be a commissioner assisted by his deputy.
Yes.
But for us, the president is deputized by the deputy
president
or by the vice president. Now, on the vice president, when you look at Article 108, it talks about the vice president of Uganda.
108.
Yes, 108. It talks about the vice president of Uganda, who shall be appointed by the president and approved by Parliament. Now, that's what we call it checks and balances. We shall be addressing our mind to it when we look at separation of power. Now, then from there we shall come to section 7.
Section 7
of the order in the council.
He vested the crown land in the
to the commissioner. Now, now that's the 1902 order in council. But now when we go back to Buganda Agreement, we have section, is it Article 15 that gave the distribution of land, whereby Namasole was given 16 square miles, the Kabaka was given 350 square miles of private land, yes, like that. Now, when you come back here, we are going to look at Article 237. It talks about land ownership, how land is being owned under customary. 237. Crown land, freehold, Milo land. I think council, when you also look at section 2 of the Land Act, it also gives the land ownership, how it's being owned in Uganda, but they brought directly from the Constitution. You also come and look at Article 238. It talks about the Land Commission, that it will be responsible to govern the land, to control and govern the land of the state, of the government.
237.
237 talks about land ownership. 238 talks about the Uganda Land Commission.
Establishes Uganda Land Commission.
Yes. Now you are seeing how we adopted it in our constitution, right? And also it gave the birth of the Ministry of Land and Urban Development. So we are looking at the ways how this 1902 Order in Council contributed to the constitutionalism in Uganda. One, we said it was also captured in the constitution, right? Article 138, and also it gave the tribunal or the office of the inquiry or the commission under Article 238, the Uganda Land Commission. It also led to the establishment of the Uganda of the Ministry of Land and Urban Development. All those ones have contributed to our constitution.
Yes.
Then we shall also look at section. When you look at section 10, from section 10 from section 8 to 10,
yes.
it also empowered the commissioner to make laws. Meaning the commissioner had the mandate to make laws on behalf of the citizens, so for easy governance of the protectorate. Now you come back and look at the constitution. Under Article 79, Clause 1, Parliament is empowered with the powers to make laws on behalf of Ugandans for easy governance, peace, development, and order. But now, Council 79, Clause 1. But now the question will be, if Parliament is empowered, when the Minister of, for example, of Kampala, when he was chasing all the vendors, did he go to Parliament? Still, Parliament is given that allowance, is given that time, that power, that authority to delegate this mandate to other government entities to make laws on its behalf. I think that's Article 79, Clause 2. It says, except. Now, that's what we call delegated legislation or subsidiary legislation.
Yes.
And under subsidiary or delegated legislation, we shall be seeing statutory instruments. Those are laws that are made by the ministers. We shall be seeing ordinances. Those are laws that are made by the district council. Passed by Chairman LC5 after consulting the Attorney General under Article 119 of the Constitution, because it's the legal advice of government. And then we shall be seeing bylaws. Bylaws, these are laws that are not, if the laws are not coming from Parliament, from the minister, from also the district, it becomes a bylaw. So these are the things that we are going to be looking at. Now, here on the section 8 to 10, the commissioner was empowered with the mandate to make laws, right? But for us here, on Article 279, so Parliament is empowered.
But here, there is an element which was also lacking, which I want to bring in. When we talk about the commissioner here being empowered with the power and authority to make laws, I think here the president, because if you look at the current law process, other than the private members bill, but other laws are initiated by the president. Majority of the laws.
The president can influence.
He initiates.
Can influence. Quote me well. Yeah. He can influence for the passing of the bill. Now, like this insolvency bill, he had the interest. The AJ amendment bill, he had the interest. But for him, he does not make. He can influence the members of parliament or the ministers.
I'm saying, initiating, starting it. Atandika initiates the bill. For example, he wrote to his social media handles, and he said that people who I sat with to draft this bill, they changed and they chipped in their what? Their selfishness.
Now, Council, when we go back to the lawmaking process, the lawmaking process, how does the bill turn into a law? The president can influence, okay, he can guide, but he does initiate. It means like he's the one who commences for EC starting. He's the one who introduces.
That's the practice here in Uganda.
No, like okay, in practice he can influence, but he cannot initiate. It's the member of parliament who is not a minister who can initiate, and that one we call it a private member's bill. Or it can be a minister sitting in the cabinet who can initiate what we call the cabinet members bill, or the government is bill. So the president can sit in the cabinet and direct them on what to do, and then for them they come and initiate that bill to parliament. But he cannot formulate a law, but he can influence.
It's okay.
Yes.
Let's proceed.
Now we are also going to look at which section? We are going to look at section 15, subsection 1. It establishes a system of judicial power comprising of courts of judicature.
Yes.
Now, that's hierarchy. When you come back and you look at our constitution, is it Article 129? It talks about the courts of judicature in Uganda, which are comprised of the Supreme Court, the Court of Appeal, the High Court, and other subordinate courts as made by Parliament established. And that's where we shall find maybe these magistrates, the Kurdish courts, the family court, the LC court, the military court. So we are seeing that in the Ordinary Council of 1902, they formulated a system of bringing up courts. And even we are seeing in our constitution, we have what we call courts of judicature with a different jurisdiction, with a different structure, right?
Yes.
Now, meaning here we are going to relate it with Article 129. We also come and relate it with Article 126, because when you look at Article 126, it talks about the exercise of the judicial powers. The judicial has the mandate to resolve disputes. We shall also come and relate it with the Article 128 of the Constitution that talks about its independence. Because when you look at Article 128, I think 128 clause 1, it says that the court shall not be subjected to any external authority by any other person. All those and they are showing its independence.
Yes.
Right?
Yes.
Then we shall also look at section 15, subsection 2 now. It talks about reception clause. Now, counsel, when you look at reception clause, it comes from the word receiving, right? Meaning, we received the laws from our colonial masters and we adopted them. We started applying them. That's why, under the presumption of innocence, that's Article 28, Clause 3, Paragraph 5 of our Constitution, we normally apply there the case of Wilmington versus DPP. Meaning we received the cases from our colonial masters, from other countries, and we started adopting them. When you go back and you look at the Judicial Act Council, under section 14, subsection 3, it says that the court shall apply the doctrines of common law and equity when they are resolving matters.
Yes.
That's why we have those cases, Fisher versus Bell, Wilmington versus DPP,
Adams versus
Judicial. We have the R versus Ameko, R versus Kachingita. We adopted those laws, we received them, and we started applying them. You get? So you are seeing even in our laws, they are trying to bring them. They are telling even that the High Court and also other courts shall apply the doctrines of equity and common law when they are resolving disputes. That's why right now when I tell, please, but who has the burden of proof to prove that Okello committed the case? The only statement you tell me that, the burden of proof reserves on the state and it must prove it beyond reasonable doubt, as it was being laid in the case of Wilmington versus DPP. Meaning we are using the past cases that we adopted from those colonial masters to resolve our current issues.
Okay.
Then we shall also look at Article 15, Article 20. It talks about what we call repugnant clause. Now, counsel, any law that is not in line with the Constitution, it becomes repugnant. Any law that is not in line with the rules of natural justice, it becomes repugnant. When you go back and look at Article 2 of the Constitution, it talks about the supremacy. But on Article 2, Clause 2, it says that if any other law or custom is inconsistent with the provisions of this Constitution, that law or custom shall be declared null and void, and the Constitution shall prevail. Meaning it becomes repugnant. When you come back and you look at Article 32, Clause 2? Article 32 talks about, I think, marginalized groups. Now, on Clause 2, it says that any law, custom, or culture, laws, cultures, customs, or traditions which are against the dignity, welfare, interest of women, or any other marginalized group to which Clause 1 rates or which undermines their status are prohibited by this Constitution. Whatever law you make, but the law is against the provisions of this framework of the Constitution, it becomes repugnant. Eteka lyonna lyoyisa naye nga the undermining oba is not in line with the Constitution, it becomes repugnant. Libafu. For example, we are aware that prostitution is not allowed. For the moment you start up a company that is promoting prostitution, based on the case of Peace versus Brooks, it becomes illegal and it becomes repugnant.
Okay. So you are saying that all acts of parliament which has been nullified by the constitutional court,
They are repugnant.
they are repugnant acts.
For example, the Computer Misuse Act.
Yes.
They said that it was infringing some of the provisions of the Constitution. And we are saying that the Constitution under Article 2 is the supreme law of the land. So in case Parliament makes laws, all court makes laws under what we call judicial precedent, but those laws are against the Constitution, then they become repugnant, and we shall go to the Constitutional Court to interpret and so that those laws can be nullified.
Kakati abatuwuliriza muteekwa okumanya ebintu bino babasabye Oluganda kanjogerayo ebigambo bibiri mu Luganda. Paalamenti yaffe erina okukola amateeka agatakontana na ssemateeka.
True.
Paalamenti yaffe okusookera ddala nga tetunagituukako, mwe abalonzi mulina okulonda ababaka ba paalamenti abagenda okukola ebintu ebituufu, abamanyi ebintu bino. Si kyo kanso? Kati for example yesterday okimanyi nti ababaka bayisiza etteeka eryo nga tebalina kye bamanyi wadde. The 355 MPs ababaddemu tebasomye bbiiru, tebakoze kintu kyonna, bagenze bugenzi. The I have it.
Did they have the quorum?
They had the quorum this time round.
Now it will come back to them. When they go back to the electorate and they question them, they will start saying, for money.
No, kati, you see obuzibu tulina obuzibu with the electorate. You know? Kati nze ndi wano nsoma mateeka. You know? Kati otuuka okusaba akalulu nga you have an idea on the law making process, ne bakatakuwa. Ne bakawa omuntu omujega atalina kyamanyi. Kakati etteeka liryo lyayise. Lirina direct effect ku muntu wa wansi. Lirina direct effect ne ku mukulembeze. Naye we baliyisizza because they are serving certain interest somewhere. Okay? So, the big question goes back to the voters. Can you distinguish these issues for sure? Nti abantu besimbyewo naye osobola mulimu ki? Osobola okukola amateeka? Because eryo etteeka era oliraba nga it's a repugnant act. It is going to be challenged in the constitution.
I understand your submission, but we say that if the court makes a judgment, that judgment becomes valid until it's being appealed and may be reversed. So if Parliament makes any act, it becomes a valid act until it's being challenged.
Yes.
So in case these people come, you and the rest of the Ugandans, the moment you go to court and you challenge it, and the court agrees with you, then it become nullified and become.
But me, my concern is, as a taxpayer, the process of making law, it is very expensive. They were paid allowances yesterday. They facilitated the committee process. They invited stakeholders. Okay? That is money. So now, bumba maso kole teke muisem process eyo na musasanyiza 3.5 billion. Okay? Over 5 billion. Okole teke mama akalikola court nerikuba. Abayibo musoro tufunirawa.
Nanti kakati mba ndaba fa baba fiirwa. What the fact that baba mazo teka allowances zaabwe government kuba tulina kibayita the certificate of financial incomplication. When they are going to pass it, yes, they make it. I think that's under Rule 170 of the rules of procedure of Parliament. They are supposed to be facilitated, right? But now, at the end of the day, Parliament has nullified. Now again, they are going to go back.
Court has nullified.
Court has nullified. Now they are going to go back. They start again making it again. With those clauses that the court has not agreed within. Again, that's like another city. Those are other
expenditure.
You people, our electorate, take people that you feel like they have educational background or an experience. For example, you cannot remove people that they have been in Parliament for so long, they have the background of the law, then you come and vote someone because it's an umbrella. Then Faba bafiirwa ku nkomerero. Because this person for him will keep on picking his allowances.
Okay, let's proceed the council. Kyanaku
nnyo kyenyamiza naye nga munange.
We on section 20
section 20 clause B.
Yes.
Gye twogeddeko twadde twogera ku repugnant. So we say that if any law is not in line with the constitution, that law becomes repugnant. Now, mu kuwumbawumba mu bufunze bwe tugezaako ogitemaatema order in council, we shall conclude by saying it contributed, it laid a fundamental stone.
No, before we make a conclusive remarks, we have 20 again to 25. There's a clause there.
Now, when you look at 20,
section.
From 20 to 25, I think it gave the removal of the what? Of the deportation of any
deport. Deport. Or to remove any person from the protectorate.
Yeah, that power to remove any person.
Maybe you can read there.
When you look at here, council, we want to see what contribution did this article contribute to the development of our constitution?
Because it by then it was challenged by Ibingira'S and others.
You get what I'm trying to say? So when you look at this one, they say that it provided for the commissioner to order the removal or deportation of any undesirable person from the protectorate in order to preserve peace. Now, this one, I think it was more of infringing someone's rights. Now, the moment you could speak, they could deport you.
Yes.
Or they move you from the protectorate. And that one did not contribute to any constitutional development. According to you, did it?
No, but it's a leaf. It's a leaf.
Yes, it's a leaf that peace can be there. But remember now, when you come back to our constitution.
No, what I'm saying, I think we need to know that bad laws has been there before.
But yes, bad laws have not been there. But not every bad law. That the fact that it's bad, the meaning for it did not have any positive impact.
So we cannot use it.
Yes, that's why they struck it out on the development of our constitution. Because any section you put, for example, council right now, when you look at Article 26 of the Constitution, you have a right to own property, either individually or in association with other people, right?
Yes.
Now, the moment I make a law, again, I'm denying it to own property. Is it contributing to the development? I can strike it off. So this one, you're going to see that it empowered the commissioner to deport people any person, or to move any person from the protectorate who was against their rule. I think that for it was.
But it is exactly like the sovereignty bill. Because for it, that's why I've called it. It's a different what clause, which we can do what we can internalize and make a comparison. It was about anyone who is chaotic, you do what? You deport. The commissioner to deport or to chase him away by using any means available. It is exactly these people, they were enacting law that can exclude Ugandans who are outside Uganda. That they
were enacting, but they didn't enact. Now, council, what you have to know that for a bill to become a law, it must go. You look at the case of Miriam Matembe versus Attorney General. Miriam Matembe another versus Attorney General. For a bill to become a law, it must complete all the 3 stages. That the fact that they had brought those clauses there, but by the time of passing, they removed them. And they didn't add them in the sovereignty bill. Now we cannot say that they were part of it. Because a bill to become a bill, when you look at Article 91, clause 2, for Parliament to sign on it, to become a law, meaning it has gone all through the due process. So by the time that they had brought
the process is fraudulent,
yes,
influenced by
yes, it has gone through all. Meaning a bill can be nullified at any time. Before a clause can be nullified at any time before being enacted under Article 91, Clause 2 and under Article 91, Clause 5, whereby Parliament passes it of the Constitution. So these clauses that you are talking about, yes, initially they were there, but I believe because of the people's demand and pressure, they were struck off before being passed. At least they polished somewhere. So we cannot hammer them that you passed this. Yes, it was there in the process, but by the time of enacting that bill, they were quashed.
So can you, if possible, can we look at this case of Ibingira versus Uganda in line to this clause, section 20, 25?
Section 20.
And you think the argument and the reasoning of the court.
Now, the question, what you have to first know, what was the Ibingira case about? Deportation. Right?
Yeah.
Now, when after the month of the 1966 Kabaka crisis, government wanted to consolidate its power. That's when, at that eve, it came and moved the kingdoms in Uganda, right?
Yes.
And then it passed the emergency laws.
All other cultural leaders.
Yes, all other cultural leaders were abolished. And then they brought the emergency regulations, and then they also passed the deportation order rules now.
And the detention orders.
Yes, detention orders. That's what you have to know. For the case of Ibingira, the case that we are going to talk about, we are going to see different principles in this case. One, we are going to see the legality of the 1966 Constitution. As you know, the 1966 Constitution was more much of it appreciated cultural traditions, rulers, than the rights of individuals, like what this Constitution is doing. Meaning, we are going to be looking at the validity of the Constitution by then, and even whether those emergency regulations.
Which Constitution? The 1962 or the
1962?
Because the government had collapsed.
Yes. So we are going to be looking at the validity of the 1962 Constitution, and even then we have what we call the principle of legality. When you look at Article 28, clause 7 and 12, it says that on Article 28, clause 7, Article 28 talks about right to fair hearing. On clause 7, they say that no one shall be charged of an offense that is not laid down in the statute. On clause 2, there's an exception there. Only contempt of court. Remember the matter of Aaron Chiza?
Yes. Even me. Yes. I was detained in Uganda Road for contempt of court.
For contempt of court.
For 8 hours.
Now, it's only contempt of court that is not laid in the statute that they can charge you of.
Yes.
But besides that, no one now. When you look at the Kabaka crisis, immediately it took place. People started sitting in the cocoons, in the meetings, hiding places. This government
planning for
what next for the move. Can we demonstrate and do this and this?
Remove this government.
The government was also very wise. They passed what we call emergency regulations, rules. But those emergencies, they were going to be applying within the region of Uganda, not other regions. So these guys that were trying to make those meetings and whatever, they were arrested. But then they arrested them before passing
the emergency
regulations.
Yes.
Now it will take you back even to the case of Atugoza versus Attorney General, whereby he was being charged of corruption offenses, but by that time the Anti-Corruption Act was not in force, and then the state wanted to use the act on him, yet by that time he committed those offenses, it was not in the force.
Yes.
So you're going to see that when these guys were Ibingira, the rest of Matovu, when they were being arrested, by that time the emergency laws were not there. And even the detention order, the detention order, those orders that they had formulated, they were against the Constitution. Because for them, they were saying that a person can be taken into a custody, can be detained without being accorded a right fair.
My question is, they were against the Constitution. Which Constitution? The overthrown Constitution of 1962?
Yes.
Was still in force?
Whenever a revolution takes place,
yes,
the orders they bring, they become valid.
Yes.
Professor Kelly. Yes, that's what he says. Now, but for it, remember these judges of the court, when they were serving, which constitution did they use? The 1962 constitution.
Yes.
So, taking the matter to the court, maybe for them they were still believing in what?
1962.
1962 Constitution. So we were determining its validity, and even the decrees that the Obote had made by that time, was it legal? Remember that when the president rules without parliament and the constitution, meaning is ruling with the decrees.
Decrees.
So we are looking at the validity of those.
So the question in the case of Ibingira was the what? The legality of 1962 Constitution.
Yes, and even those laws that they were passing, were they in line with the Constitution? Because council, you cannot tell me that if the Constitution says something, then for you formulate a law that is against it, it becomes invalid.
Yes.
It becomes void. Even here under Article 2, Clause 2, that's what they are telling us now. You're going to see that the deportation order, the detention order that they had formulated and the emergency laws, they were not in line with what the Constitution that was saying. Because for them, they were saying someone can be detained without even getting a fair hearing and gets a punishment, and which was violating people's rights.
Yes.
Eh? You're telling people that they shouldn't talk about their rulers, their traditional leaders. Yet we have what we call customs. When you go back and you look at is it section 15 of the Judicial Act?
Yes.
It says that a high court shall preserve the existing customs as long as those customs are not against the rules of natural justice.
Yes.
As long as those customs are not against the Constitution, then the court shall be there to preserve. I get it. Yes. And we also have a right to belong to a certain culture that we want, under Article 37 of the Constitution. So, but we are seeing that these people, they are denied to participate in their culture. They are denied not to talk anything. I get meaning they don't have freedom of expression. They are denied not to be accorded the right fair hearing. So all those they were invalid, and that's why the East African court, had to strike it off. Even though our Ugandan High Court, it believed with them. Of course, that element of influence. But when these people went back to the
executive influence,
yes, to the East African Court, for it said, whatever the High Court had done, they had erred the law, and in fact, so it was against the rule of law, right? Now, the East African Court ordered for their immediate release. But when these people were brought back from, of course, now by that time they had detained them in the Karamoja. Now, when they were on the way, immediately they landed on Entebbe. Because the emergency laws were applying within Uganda, and Uganda is in within, and Entebbe is in within Uganda, so they had to arrest them.
So they used the chopper to fly them?
Yes, I think. They used the chopper.
They arrested them from Uganda and detained them
in the Karamoja. Yes.
Just like what happened to Dr. Besige. As they say, history repeats itself anyway. Hey. Even Dr. Besige was chatted to Karamoja.
But now, when we'll be looking at a lot of principles, Council. Do you know that under Section 14 of the Judicial Act and under Article 139 of the Constitution, the High Court has unlimited jurisdiction. So territorial jurisdiction does not apply to her. It only applies to magistrate courts. For them, they have geographical. They have the cases that are being committed within their area. But High Court, they can. You remember Mumbere, King of Kasese, Bakonjo. When he was arrested from there, he was brought to Kampala. The High Court has territorial unlimited jurisdiction. They can try you anywhere. But for them, their element here, it came with it. Emergency regulations rules. I get why didn't they try them from there? They had to release them, but immediately they brought them back and then they landed on the Ugandan land. Uganda land. They had to capture them. But why that whatever was being disputed and why was being argued about and set aside is that they made those laws. By the time they arrested those people, those emergency regulations laws were not in place, and that's the principle of legality. You cannot charge me an offense. The offense is not laid down in the statute. So by the time they had charged them, it was not laid down in the statute.
Okay. Anyway, as we finish, Council, what's your conclusion on this matter?
One, the 1902 order in Council it was the first major legal framework of the entire protectorate that contributed much to our constitutional development, apparently the 1995, because you're going to see that most of the sections in that order in council, they were being merged. They brought the framers of this constitution, they brought the leaf from the 1902 order in council, like land demarcation, boundaries, how to pay revenue, the courts of judicature, having a commissioner as the head. You're going to be seeing this, or even we have those the president, how the revenue is being paid, the consolidated fund, paying taxes under Article 17, paragraph G, whereby every citizen has a mandate to pay taxes. So, in the conclusion, it was the first fundamental legal framework of the entire protectorate. Because for Uganda, yes, it was a legal framework, but for it was more of Uganda than the entire protectorate. And you're saying that the order in the council for it covered the entire protectorate.
So you are saying that in conclusion,
the 1902 order in the council was the first fundamental legal framework of the entire protectorate.
First fundamental legal framework. Yes.
Over the entire protectorate.
The entire protectorate. Yes.
That contributed to the development of constitution.
That contributed the development
of the 1995. Because remember, whatever we are discussing, we are touching it with the 1995 constitution.
The 1995 constitution of Uganda. Full stop. Okay. Yeah. Thank you guys for today's work.
Thanks for the time and
abatuuliza baffe leero katukome wano tuba tunozaako mu order in council. Bino ebintu abazungu babisetinga babitulekera wano, ebibi n'ebirungi twabisikira nakati tukyabonaabona ku nsonga y'amateeka tetunagisolovinga. So next time tujja batwalako another amendment. It is now known as order in council 1920 ya 1920. Amateeka gaze gakyuka paka etutuuse olwaleero. So njagala okubeebaza, mwebale okubeerako, mwebale okutuuliriza. Eno sho si ya lutalo. Babadde bagamba mbu tugudde olutalo ku Buganda, si kituufu. Tubadde tukuleetera gye byava, amateeka gaffe gavaawa, era tutuuse tutya wano we tuli. Abazungu bye baakolanga ne gavumenti ezaddako bye baakolanga tebikyuse nnyo ne bya NRM byekoze. Amateeka gaffe balinga ali mu buyinza, amateeka aganyigiriza abantu ba bulijjo, amateeka aganyigiriza ebyobufuzi. Just imagine detention orders twogerako mu Ibingira'S. Kugamba bakwata omuntu nga n'etteeka lye bamuvunaana teririiwo, ne bakukwata olwaleero etteeka ne balikola enkya erikukwata erikuvunaana. Ebyo byonna bye twagadde okutunuzaamu. Mwebale nnyo, mwebale ddala okubeerako.